I'm struck in reading your book that both the government's lawyers, the Times lawyers, and the judge are all sort of thrown together very quickly without knowing much about the Pentagon Papers.
It's like three different tracks all coming into the courtroom, and each one is quite fascinating in and of itself. You take the Times lawyers, for example. And it ended up being Floyd Abrams and Alexander Bickel. Floyd at the time was at K.O. Gordon, and Alexander Bickel was a prominent professor at the Yale Law School. And the way Floyd tells the story, he and Bickel went down to the law library at Cahill Gordon to jump into the 1917 espionage laws, only to find out that they were exceedingly complicated, and it was very hard to parse them out at 2 or 3 in the morning. But they did by 9:30 when they had to go to court. So that's how they got there, and they got there really late at night, you might say, in being woefully underprepared. Mike Hess was the assistant U.S. attorney at the time. He was home on Monday morning when he received a phone call from Whitney North Seymour Jr., who was at a conference in Washington. And the way Mike tells the story, he was shaving and his face was full with shaving cream, and he gets a phone call, and Mike says, "You have to go to court and represent the government. We're going to sue the New York Times for a prior restraint." Of course, this has never been done before, but get yourself together and get there and just do it. And Mike didn't know anything about the case, not a thing. He never knew about the Pentagon Papers study. He barely knew what prior restraint law was. I mean, this was like 7 o'clock in the morning. He had to be there, I think, at 10. Murray Gerfine is your third track. He's the judge. He was a patent lawyer. I don't think Murray Gerfine knew a lot about First Amendment law. And he had just been appointed to the district court bench by President Nixon, and he was sworn in just the previous week. Monday morning, or Tuesday morning, June 15th, was actually his first day on the bench. And the Pentagon Papers case, oddly enough, was his very first case.
And so what happens in that courtroom? What's going on in the judge's mind as he thinks about whether or not to grant the government a preliminary injunction?
One might say that Murray Gerfine began the proceedings on that Tuesday feeling as though the primary obligation on behalf of the Times was to be a patriot, and that anybody or any institution that was going to be patriotic would cease and desist voluntarily publishing these documents. So in fact, he turned to the New York Times and says, "I would like you to understand your duty as citizens and to voluntarily stop publishing these materials." And Mr. Bickel, on behalf of his client, said, "We can't do that." And so after a short hearing, the judge entered a temporary restraining order. Right?
And something happens between that first hearing, when the judge goes one way, and the second hearing, where he rules in favor of the New York Times. What's going on?
Well, he schedules a hearing for Friday, right, which is going to be the June 18th, where the government would come in and presumably offer evidence in support of its request for a preliminary injunction. It lasted for about 4.5 hours. And somewheres after about an hour and a half or two, where the government witnesses refused to cite chapter and verse for the judge. So they were unable or unwilling to point to particular pages in the 7,000-page study and say, "This is what we're concerned about. You can read it, and anybody can see that the disclosure of this information will harm national security." They didn't do that. They just didn't do that. And the judge invited them to do that over and over and over again. And by the end of the in-camera hearing, Murray Gerfine, who started out asking the Times to voluntarily agree not to publish this material, turns down the government's request for a preliminary injunction on the grounds that, as he said, no cogent reasons were provided to justify a preliminary injunction.
David, I want to pick up on something else you also wrote about, which is the debate after this ruling about whether the Times gave up too much, in a sense. There's the famous back and forth between Potter Stewart, where he's pushing Alexander Bickel about what if the disclosure of sensitive information, the hypothetical, the disclosure of sensitive information in wartime would result in the sentencing to death of 100 young men whose only offense had been they were 19 years old and had low draft numbers. And he kept pushing and pushing, and finally Bickel said, I'm afraid that my inclinations of humanity overcome the somewhat more abstract devotion to the First Amendment. So what did come out of that ruling?
Well, the Supreme Court wrote a per curiam opinion, which really said the government has a heavy burden. That's all the per curiam opinion said, that was signed on to by the 6 people in the majority. And they didn't define what a heavy burden was. And so I guess if the question is, should the Times have pressed harder for a more protective legal standard? Should Alexander Bickel have turned to Justice Stewart and said, well, if you go back into chambers and find information that will result in the death of 100 soldiers, then we still think that the injunction should be denied because the death of 100 soldiers won't inflict irreparable harm to the New York Times. Well, should you have said that? I don't think so. The case was on the line, and if you're going to be a good lawyer, you want to win the case. Having a nice principle is a good thing, but losing a case of this magnitude at this time in this setting would have been a total disaster. And Bickel, on the spot, made the judgment that he had to carry Justice Stewart if he was going to win. So this particular moment where Floyd, or where Alexander Bickel was asked this question, he only had one answer he could give, which was, if you think there's information like that in there, then you have to grant an injunction. But I don't think there's any information like that in the documents, and that turned out to be the case.
I find it a very hard, very hard question, David, and not simply a tactical question. I find it on the merits and substantively a very hard question to respond to. I think what made it easier, as it turned out, was the second half of the answer, which often gets eluded, and that is, but there is no such information in these documents.
I think there are 2 questions we're wrestling with here. One is, are there any limits, should there be any limits to what the press publishes? Should it have self-restraint about certain matters that editors themselves would concede would be harmful to the national interest? And the other question is, can or should the government do anything to stop these leaks? Let me just address each quickly, because I think these are the core questions. I don't think the government can do a damn thing to stop these leaks. All the journalists on this panel can tell you leaks happen in so many different ways, you can't begin to imagine how to plug them. These happen in so many ways you can't begin to track them. The government is at an almost complete loss when it comes to protecting its secrets. Now, what about the press? The burden is then on the press. Should it show any restraint? It never really did. It never really did. The Chicago Trib was publishing World War II battle plans. Can you imagine that? I can't imagine anything more secret than that. We used to have debates inside the Times on whether to publish certain things, but they almost always resulted in publication at one time or another, in one way or another.
But back to your first point, I mean, if the government cannot control its secrets and leaks, what has been put on the table is whether the government can then punish somebody for those leaks.
There are 2 kinds of leaks that I think can be deterred. One is the sort of policy kind that I mentioned, and that can be deterred by vigorous prosecution. I mean, you hang a few, and it discourages a lot of the others.
Where has that happened?
Hasn't. It's happening under the, by the way, it's happening more under the current administration than it has happened in the past, to their, in my view, credit. The stuff like WikiLeaks can be stopped. You start to get a pattern of charges on your credit card. You get a call from your bank asking you whether you're on vacation in Bali. You get a dump of 250,000 cables to some guy in Peoria there has to be a way that that can be stopped and detected. The technology is there. All it has to be is applied. And I'm sure that it will be applied at some point, good and hard.
A complicating factor is that the laws that we have don't fit very well. My personal view is that it would help if we had a streamlined leak law, and I personally think that we can write one that is cleaner. On the subject of
Give me an
punishment,
idea what that would look like.
well, I was comfortable with the one that was written in the simple law that has been long supported says a person who knowingly leaks information that they know to be classified is committing a crime.
Is that streamlined? I mean, because
Well,
we
if you
classify so
know-
much information.
Well, I have seen lots of things go across my desk which I say, this is not classified, but that's not then up to the individual government official to second guess and say, that shouldn't have been classified, therefore I can disclose it. You know, the two laws the government relies on are the 1917 espionage laws, which for the reasons we've discussed don't fit very well, or the Theft of Government Property Act, which basically says someone who steals government property is committing a crime. And we have prosecuted people under both statutes, but it's very difficult.
But I think it remains the case, as Adam says, that the hard case is the WikiLeaks case. They aren't a government employee. Private Manning was a government employee. I don't think anyone at the table here would likely say that if it was Private Manning who did it, that he has some First Amendment right to leak all this information. The hard question is, do you want to have a statute, a cleaner statute, but also, in my view, a more dangerous statute, which applies to third parties who are given, who receive information which is duly classified?
Let me say two sentences on Assange, following up on something you said, Floyd, which I have sort of mixed feelings on prosecuting Assange. On the one hand, I think he has done something truly horrible. As someone who spent 4 years at the State Department, this is so demoralizing. All the Foreign Service would just like to quit. On the other hand, I have reached in my own mind the feeling that sadly, some significant number of people feel that what he does is a good thing because it is exposing what the government does, that we would make a martyr out of this man.
Do you want to make a case for prosecuting Julian Assange?
I think the case can be made under the dirty old I mean, you want a clean leak statute? I don't think we need a clean leak statute to get at Julian Assange. There's information in there about, as you said, the identity of Afghans who cooperated with the United States. There's information in there that can be used directly to target people and places. I don't think it's a problem prosecuting Julian Assange.
But he has no First Amendment rights. He's not protected the way the Times is protected, that used the same material?
Who says the
I'm
Times?
not sure if the judge concedes the Times.
I
is
don't.
protected.
There we go.
I don't concede the Times is protected.
Oh, that's what I want. That's my question. Is the Times
They may be
protected?
no, not at all. I mean, the statute
So
says
what's the chart?
the statute says whoever. It doesn't say whoever other than a journalist.
You know, I've tended to have two perspectives on this in my life. When I was in the government and information was leaked that I was working on that made my life harder, I didn't like it. For the rest of my life, particularly as a journalist, I was by and large quite pleased with the leaks and pleased as a citizen about the leaks, because I thought it gave us a much better chance to discuss the real considerations that were being discussed inside the government. It is painful for the government to have those revealed. But if we're going to have anything resembling a realistic debate on the outside about critical foreign policy issues, this information is essential to it.